format I like to use is very interactive. So I'll kind of tell a little bit about what I've been working on, some of the issues that are going on, but I'm going to ask a lot of questions, not a quiz or anything. So don't expect to have any answers, but I do expect you to have opinions. As she stated, I founded Hernandez Strategy Group. I think a week ago was my 17th anniversary of setting it up. And let me tell you a little bit about it because it tells you a little bit more about me. When I left the state capitol, I had no intention of getting into lobbying or political world. I wanted a break. I wanted to completely get out of it for a lot of reasons. And I was going back to just practice law. And my first week out, I had my office, I hung up my shingle. It had been a while. I had taken some time off. I was in the Capitol. I had one legal client, my first week out, so I figured that was pretty good. I got my cell phone. At that time, it was a little bit larger, different, not quite a computer. And about 2 days into my first week of opening up my office, I received a call from 2 different organizations, both of whom I had come to know while I worked in the Capitol. I worked on legislative proposals with them. And they both called me and said, hey, well, guess what? We want to work on the bill that you worked on previously. We want to rerun it because it wasn't successful, but we want to try it again. And you know more about it than anybody in the Capitol because you've worked on it for the last couple of years. So we want to hire you to lobby on the bill. And they said, you're lobbying now, right? You opened up your lobbying shop. So let me go back. I had one legal client because I just opened up my office that week. And I said, yes, as a matter of fact, I am going to be lobbying. So that's kind of how I got into lobbying. It was not really a career path, career choice. It just kind of happened. But I've always been an advocate. And when I went into the state capitol the first time, it was at the request of a then state assembly member. He knew I was doing a lot of work in criminal defense, but also criminal justice and reform. And he said, you know a lot about the policy issues. You know a lot about the community impact. You work with folks who are trying to change the system. You are out there engaged in pushing policy changes. It's great. He says, but what you don't know is how it really works behind the scenes. And I've told the story before, he reminded me that a few years before, I think before I went to law school, I was involved in a movement to pursue a civilian review board for a city police department. Create a board, community members, keep an eye on their behavior because, as bad as things are now, it was just as bad back then. And we had organized several hundred, I think it was close to 600, over 600 community members to show up to City Hall and to speak in favor of a very broad, very strong civilian review board model, one which would allow the review board to subpoena records, subpoena witnesses, and really investigate when law enforcement has some questionable activities. And after several hours of testimony, all in favor of our proposal, the mayor pulled out a typewritten statement. She already had it prepared, read off of it, and explained why she was not going to support, and the council was not going to support our proposal. And he reminded me of that. And he said, you did all of the work necessary, all the community work, and you pushed the right proposal, and you guys did all your homework, but the decision had been made before you showed up. Okay. And I said, well, thanks for reminding me. It wasn't a pleasant evening, and I felt very bad for all the community members who, even though a lot of them were very fearful about coming to City Hall to challenge the police department, they came out nonetheless. And so he asked me to go to Sacramento. He says, go to Sacramento, work on criminal justice policy, which would be a consultant on the Public Safety Committee, explain a little bit more about that, for just 2 months. And then take that information and that knowledge back to the community. And you're going to be much more effective. Okay? Good deal. So I did it, packed up my stuff. That was on a Thursday afternoon, and by Monday, there I was in Sacramento in my new office. Didn't know what the hell my job really was. But essentially what I did is I reviewed every piece of criminal justice legislation that's introduced. And it was right about this time, Actually, it was mid-March. So it came in right when all of the new bill proposals were being reviewed for the first time, were being prepared to be voted on for the first time. I got a stack of bills, criminal justice bills, and my job was to read them, analyze them, and make recommendations to the chair of the committee, whether to support them, whether to change them. And I tell you, it was both amazing, overwhelming, and very troubling, because I consider myself pretty politically engaged. I know what was going on. I was working in the community on all of these issues. And here was a stack of bills that, but for me sitting in the room, having this job of looking at every single bill, I never would have known about most of these proposals. What you hear about in the newspaper or now through social media about bill proposals in the state capitol is a small fraction of what's actually being debated and voted on in Sacramento. And it was very, very concerning for me. And I realized that all of the folks I was working with on the ground in the community had no clue, just like me, had no clue about these decisions that were being made. And on top of that, the legislators who were making the decisions did not have the opportunity to hear from us on each one of these bills. Now, the big ones, yeah, people got involved and come and testify. But all the other ones were being decided by folks that maybe had some background, maybe not, ended up on the committee because maybe they made the speaker mad, so they got this really terrible committee to sit on. Right? I mean, there's a lot of different reasons why they end up on a committee. But what I realized then, it was at that moment that I knew that all my advocacy that I had done before, on the ground, as a student activist, whatever capacity, as an attorney, as a professor, I was always kind of rebel-rousing. That's just kind of how it is, right, when you see problems out there. And so I realized at that moment that I had to find a way to be an advocate in this world, in the legislative world, because there's just too much of a gap, okay, between everyday people doing, going to school, working out in the community, and the decisions that were being made literally behind closed doors, okay, or in the hallways, or over coffee, or over dinner, or over drinks. And so fast forward, when I left the Capitol, I had had a few years under my belt, both a committee consultant, then became a chief of staff for a legislator whose primary policy goal was criminal justice reform, so it was a good fit. And when I left and I got the call to be a lobbyist, I realized that's exactly what I had thought about when I first arrived in Sacramento, was being an advocate in the policy space. So why don't I do that? And what I committed to do was to create a lobbying political consulting firm and litigation firm, because for a while I was doing both, on the left of center, okay, as far as the political spectrum. Social activism, social justice issues, civil rights issues, criminal justice reform. That was my goal. And that's what Hernandez Strategy Group became. It was first just me by myself, and then eventually I added staff, and I've had a number of folks come in. They're really good folks. I'll talk about them in a little bit. And I eventually became known as the lefty lobbyist. And at that time, when I opened up the firm, there were, if I remember correctly, I think there were 3 Latino lobbyists that had their own business. That's it. They worked for corporations. Those were their clients. There really weren't any left of center, liberal, progressive lobbying firms. There are now, but there weren't back then. So when I came up with this model, I kind of looked at like the mall devs, and I looked at some of the other institutions or entities that are already out there, and I wanted to create kind of an advocacy firm. I spoke to a lot of folks in Sacramento, some folks who've been around for a long time, very well known, and all but one of them told me not to do it. All but one of them said, there's really no way you can sustain a business being a lefty lobbyist, being a progressive lobbyist. Either go work for an organization, go work for the ACLU, or just go and lobby for corporate clients. That's the only way to survive. So when I hit my 17-year anniversary, I always think about those folks. Most of them are still around. And I just tell them, in my own mind, I have a little message for them whenever I see them. And the point being is that I think for all of you, you're all pursuing the interests that you have, right? And you're here in this program for a certain reason, or you're a community member coming to this program for a certain reason. And the message I give out to everyone is follow that, right? Follow what you really care about. Follow the issues that you are committed to. And a job or work or everything else will kind of fall into place. And that's kind of what happened with me. I've been very fortunate that over the last 17 years, I've represented primarily the California Attorneys for Criminal Justice, which is a statewide association of criminal defense attorneys. And they've afforded me the opportunity to work on criminal justice reform in the Capitol. They said I've represented them now for 15 years or so. So I've worked on just about every criminal justice reform you can think of in the Capitol. I've worked for immigration rights organizations. I've done work for Dolores Huerta, of course, pro bono, because when Dolores asks, you do what she asks. I've done work with MALDEF. I've done work with environmental justice organizations. I've done work with voting rights, online voter registration. Now you can register to vote online. I was part of the final negotiations on that. The human right to water. I worked with a number of organizations to, again, help them get, save their bill, which was dead, revive it and get it passed and get it signed. So I've been very fortunate that all of the work that I've done has been in this kind of progressive space. I've had a few others kind of more in the middle, but no corporate clients. And I give you this background for a reason. Because as I get into the criminal justice reform and criminal justice issues and we kind of have interaction, I want you to know kind of the context that I come from. Okay. I come from having, being there day in and day out in the Capitol and seeing how the decisions are really made. And being involved in a lot of the decisions, being involved in a lot of the debates, sometimes successful, not always successful. And I've done a lot of work outside of criminal justice reform. So I've learned a lot that way as well. I think last time I was here, I mentioned the wildfire issue and the PG&E issue and what do they call them? The PSPS, the public safety power shutoffs. Yes. All of those issues. Those are things that I've also worked on. Okay, and they're really kind of integrated. But the core of what I do is take an issue and find what's the right thing to do. Right? What would a social justice perspective demand as far as the correct proposal, the correct outcome? And I try to use that lens because that's who I am. Not everyone thinks the way I do. That's how I think. That's a little bit more about me and how I came to be a lobbyist. And I grew up to be a lobbyist. Talk to my children about. They asked me how to become a lobbyist. And I'm like, it's just being an advocate in a different way. So let me stop there. If there are any questions about me, my background, what I've worked on, and if not, or once we're done with those questions, I'll kind of jump into some of the policy. Question, what's your question?
What is the day-to-day job of lobbyist? Like we all know, like we hear about it, and they take, lawmakers out to steak dinner,
all the time.
Slide them tickets to the doctor meeting.
All the time.
To really
So for me, and again, I'm a little bit different lobbyist. So that does happen. That does happen quite a bit, especially with some of the big lobbying firms. For me, I'm a little bit different. And it's by choice, it's by design. My day-to-day, so let me tell you what I did today. In here, one thing. So I'll give you one example. The bill introduction deadline was about a week and a half ago. So for the 2020 year, legislators introduced their bills. There's a deadline for that. It was on the February. And so I think a total of 2,500, 2,600 bills, something like that, were introduced in the last month or so. What I've been doing is reading every single one of those bills. Okay. There's no substitute for that. So in my world as a lobbyist, I have to at least know what bills are out there that relate to my clients, or relate to issues that I care about or that I want to keep track of. So my year starts off reading every single bill. The other thing I do is then I identify which of those bills are relevant to my clients, okay? Or just relevant to me. There's a few that I'm just like, that's kind of interesting. Let's track that, put it in my tracking system. And then I work with my clients to come up with positions. So after this, after my presentation today, after I leave here and drive home, I'm going to get on a call with about 30 criminal defense lawyers. We are going to talk about criminal justice bills that have been introduced that are going to be voted on in about a week or two. Talk them through. I give them political insight as to whether they should support or oppose, why, how to do it. We decide how to do it. We write letters of support and opposition, and then I go and try to make that happen. So my job is to know the legislation, to work the legislation, talk to legislators about it, and bring my clients' perspective, their clients, but perspective to the legislators and their staff. That when they're deciding how to vote, they're impacted. Now, I don't have clients that give money. They don't have PACs, so I'm not going to fundraisers. I've had clients that have had PACs and have gone to fundraisers, and it does make a difference. But I don't do that. I don't take legislators out to dinner or coffee. I've just created a different way of engaging. And so I get to know the staff, I get to know the legislators, but I get to know them based on, I know when Ignacio comes to me, one, he's going to know what the hell he's talking about. He's done his research. But two, he's going to bring me that perspective of the right thing to do, the fair thing to do, the social justice thing to do. Oh, I'm going to shut my door. I don't want to talk to them. Or, or they'll call and say, hey, there's this bill proposal. What do you think? Should we do it? Should we not do it? The other thing I do is sponsor legislation, which I'll get to. But day to day is talking to legislators mainly about bills or their staff or the budget. And that could be legislators, it could be the governor's office. The big lobbying firms that work for the corporate folks, it's more, whining and dining, that kind of thing. So it's actually a lot of fun. I enjoy it. It's also testifying. I'm a lobbyist that actually testifies on bills. Some lobbyists never testify on bills. I actually testify on bills. So kind of back to my lawyer days, I know the bills really well. I know the arguments. If I'm trying to get an amendment, I can't get it. Then we go into committee and I fight like hell for it. And I have to be able to engage, go back and forth. Sometimes it's, pretty knowledgeable folks on the other side. So I'm a lobbyist that does pretty much everything. Not all lobbyists do that. The last thing I'll add is I've also worked on campaigns, both for individuals and also statewide ballot measure. That is a discussion for another time. How I worked on statewide ballot measure, did everything beginning to end. Yes, Nicole.
You may talk about it later, but I was just wondering, what kind of policies have you worked on regarding immigration?
So that's good. It's a good segue into what I want to talk about. So let me talk about some of the bills I've worked on, and we'll start with immigration, and then I'm going to talk to you about, I think this is really important. Okay? This talks to me a little bit more about the broad strokes of what's going on politically. Okay? You might understand a lot of it now, but I'm going to add to that. Okay? So let me tell you one thing I'm working on right now. I'll just start there, then I'll go backwards. It's actually very interesting. This is actually not a legislative issue. Well, it sort of is. So some of you may have heard of this. The California State Bar, they created a task force on technology, or innovation, they call it. And they've come up with a proposal that they say is geared towards increasing access to legal services. Sounds good, right? It's hard to find a lawyer. It's hard to find a lawyer that can actually help you, not pay a ton of money. So that sounds good. What it really is that the tech companies are kind of behind it, and they're the majority of the folks on the task force because they have to do with immigration. Their proposal is to change the rules when it comes to law firms. That's one thing. So they want to allow non-lawyers to be partners in law firms. They want to allow anyone in the legal profession or work in the legal profession or familiar. In the legal profession, you have to be an attorney to be a partner in a law firm. You have to be an attorney to share fees, legal fees. Okay, that is the law, for a variety of reasons. So they want to change that. And they also want to change to allow for artificial intelligence to be used to help people to provide legal advice. Because what the tech companies want to do is the tech firms want to essentially own law firms. And then Nicole comes in and has a question on immigration law. Or goes online and says, hey, I want an appointment. Say, well, here, Nicole, here, fill this out, all these questions out, and then at the end, it'll tell you what you should do. Or it'll tell you how to fill out the form. Okay? That's what they want to do. I'm helping the American Immigration Lawyer Association push back on that proposal because there's a lot of concern that how can you build an algorithm that will give the proper advice in a situation? And if it's wrong, how do you reverse it because someone can be reported? Okay? It's risky enough when you have a human being who's supposed to be an expert, let alone some sort of artificial intelligence. So that's something I'm working on right now. It's a little bit different. Okay, you probably have never, how many of you have heard of this that's going on? It's a major thing. You did hear about this. Did you raise your hand? How did you hear about it? What's your name?
I'm a lawyer.
Oh, you're learning. So you heard about this proposal?
Yeah.
Okay.
And I'm still flabbergasted.
Right? Well, even more so, I mean, just a side note on it, and this is also what a lobbyist does, okay? We have to have some political chops, okay? The task force was given an extension to do its work, come up with its recommendations till the end of March. Okay, so you can submit comments, they come up with a proposal end of March, and then the state bar meeting after the end of March, I think it's in May. So common sense would be like, okay, we have to gear up for a fight in May. Right? Kind of makes sense because there's a sequence. Task force, state bar. What the task force did, what I found out, only because I made my staff call almost every single day, the task force, is the task force went ahead with their proposal and recommendations before the deadline. Did you know about that too?
No, I did not,
Yes.
but I'm not surprised.
Yes. So they decided at the last second, like, oh, instead of March 31st, or whenever, 29th, whatever it was, that they're going to put out their recommendation and vote on it at the end of March, they decided to vote on it on February 24th. No notice. Nobody would know. Anybody that was tracking it at the last state bar meeting, like, oh, it's in March. My client said, oh, no, it's not till March. We found that out. So I had to jump on that. They passed, that task force passed the proposal. It's going to the state bar for a full vote as early as March. Okay, so those are things, as a lobbyist, I have to be on top of that stuff. As a lobbyist, we also have to do certain things. So I'll share this. Not for public consumption on video, but.
You are.
So
Pause.
what I can tell you is this. A lot of our work is done behind the scenes. What I can tell you is this. The recommendation in that situation, I mean in this situation, was amended to say a recommendation to the state bar to pursue or to consider pursuing. Okay. What some of us did is we worked with some legislators to organize them and say, send a message to the state bar that none of these changes can go forward unless the legislature takes action. Okay, a way to kind of stop it. Okay. Remember I was talking about learning how it works behind the scenes? You're not going to see that in the paper. Okay. The other thing you should know is as an attorney, what's your name? I'm sorry. Lisa, is we pay a crap load of state bar fees every year, right?
Yeah.
And this is politics, so let's learn how this thing works. The authority of the state bar to collect fees from attorneys has to be authorized every single year by the legislature. There has to be a bill passed every single year. If the state bar does something that the legislature is not happy about, that could affect their state bar fees or dues bill, right? If the state bar decides, oh, the legislature told us not to go forward with this proposal unless we came to the legislature, and they did that, the legislature could go, oh, well, that's interesting. I think we'll give a little break to all the attorneys and cut our annual dues to $5 a year instead of the $800 or whatever it is. That's political leverage that's going on behind the scenes right now. Okay. So going back to what I do and what I talked about earlier about looking behind the scenes, those are things that we hypothetically have been working on. Okay. Find a way to get the outcome that we want. Okay. And sometimes it takes having a little bit of political muscle and using it to our advantage. And so when we work on immigration reform, immigration issues, there's a lot of that going on. And we have to figure out, well, it's not as easy as just going to legislators and making the case, hey, this is the right thing to do. I always tell folks, if that's all it took, I would have a different job. I wouldn't need to be there because they're just doing the right thing all the time. Didn't work that way. There's a lot of other considerations. So let me just mention 2 or 3 immigration issues, and then I'll get into kind of where we're at with criminal justice issues as well. And I think I mentioned this last time. I'm going to mention a very small bill that we worked on that has had tremendous impact on immigration. Okay. And this is about, again, when you're knowledgeable, no matter what field you're in, when you're knowledgeable about your field, you find avenues to make things happen. One of the problems that we had, and this is not rocket science, and some of it's common sense, but one of the problems that we saw, that we were seeing in immigration courts, was that federal law, federal immigration law, has language about a felony, right? So someone has a felony on the record or arrested for a felony, then they are oftentimes deported and not even eligible for any discretion. Right? I'm generalizing, kind of oversimplifying, but that was kind of the effect. Problem is that federal law defines a felony as 1 year or more. And in California, what's the definition of a felony? A crime whose maximum sentence is up to 1 year. So we just had leap day, so this is actually kind of relevant. So there was an overlap. Federal law said 1 year or more. California law said that a misdemeanor, so that's a felony, is up to 1 year. So in California, there were a lot of folks that were deciding to plead up to a misdemeanor because they said, oh, good, I won't have a felony, it won't affect my immigration status. A couple years later, they ended up in the immigration court, and the immigration court says, no, that's a felony in our eyes because that's the maximum sentence is a year. And we count it as 1 year or more. So literally one day, people were being deported because of it. California's intent was that it was a misdemeanor, not a felony. But just that definitional incongruity resulted in people being deported. So one thing we worked on a few years ago was literally a bill that we have now redefined what 1 year means in California criminal law. It now means 1 day less than a full year. Like, figure out the math in that, right? What's a year? It's 1 day less than a year. If you look up the penal code, it says 1 year means 1 day less than a year, because that's what was going on. And I spoke at something like this a couple of months after that bill was signed. That was a bill that my client sponsored. And I had a woman come up to me and with tears in her eyes, and she said she was from, I forget which African country. She was a student, and she said she had 2 of her friends who were also students who had been deported because they had misdemeanors that were being treated like felonies. I mean, she said if this bill had been in effect at that time, they wouldn't have been deported. So that's where something small, and you probably didn't read it in the newspapers, it wasn't a big high-profile thing, has had a lot of. We've also worked on, just real quick, on immigration. There was, this is in the criminal justice context. In these situations, if you plead to a misdemeanor and then you realize, oh shoot, I'm going to go to immigration court, I'm going to get in trouble. I need to go and maybe withdraw my plea. I need to do something. For the longest time, you were able to do that. There was a special writ that you could file with the court, and the court would hear the argument, and then they could change. You could withdraw your plea, even if it was from years before. Then there was a court decision that said, you can't do that. It has to be an actual law, an actual statute saying that you have the right to do that. And there's no statute that says that. That was just a court decision that said you could do that. So we had to go run a bill to say you have a right to go to file this motion. But for that time period, there were folks who couldn't get their prior plea withdrawn because the court just couldn't hear it. They could not get in front of a judge. There was no vehicle for that to happen. So some immigration lawyers and some other advocacy organizations and my criminal defense lawyer association got together and we drafted it up and that happened. So now people can go into court, have their criminal pleas withdrawn, so that way they can do what they can to avoid consequences in immigration court. So those are the kinds of things that I've worked on. There's some of the more high-profile stuff out there on immigration, but we can talk about those later. Let me finish up the portion of me talking a lot and then get to your questions by mentioning this, because I was thinking about this on the way over, and she's not here. Someone was talking to me outside, and it triggered something. We're at a time right now where criminal justice reform is very, very popular in the state capital, more so than it's been in decades. Okay? There has been more criminal justice reform in the last 5 or 6 years than in 30 years. Okay? It's really amazing. And I think other folks have said this, but my perspective is, I share this perspective. But a lot of it had to do with the immigration fights back in the early 90s. Okay, when Prop 187, some of you may not even be around that. getting old. When Prop 187 was on the ballot, I believe it was in 1994, November of 1994. It was a huge fight. Okay? This was the ballot measure that had a number of really, really horrific provisions. One of which was that schools would have to ask parents and their children their immigration status and report them, okay, to federal authorities. There were a whole host of really horrific provisions in there. And at the time, Pete Wilson was governor, Republican, and he was campaigning on this. This was like his big thing he wanted. And there were TV ads of dark-skinned folks at night scurrying across the freeway. Here they come. I think with a voice act. Here they come. You guys remember that? Anybody remember that? I remember that. That was a big deal. And it's really interesting to me because of all the debate on immigration right now, especially federally, that because of that happened in '94. It passed, I think it was 57% in California. That would never pass now. But because of that, there was a lot of activism that was generated. There were a lot of immigration groups that either expanded or were formed to fight back on that proposition. And there was also the Bilingual Education Initiative and the Affirmative Action Initiative right after that. So for 3 years in a row, all 3 years I was in law school, we had these really horrific ballot measures. There was a lot of organizing that took place, especially in Southern California, especially young people, labor unions, all got together and really started fighting this. Fast forward a few years, a couple things happened. One, the Republicans lost control of the governor's seat in California. After 16 years, the Republican governor became a Democrat. The other thing that happened is there was a new term limits law. So all the legislators that were in office were starting to get termed out. Okay, it was a major shift. Okay? And this was back in the late 90s. Okay? And a lot of those legislators, including the one that I ended up working for, were politically active because of the fight against 187, against the immigration initiative. That's how they got even more politically engaged and wanted to run for office after fighting for those things. So it's really interesting to me when we're debating about immigration that we ended up with a whole wave of legislators who came in with super progressive ideas, wanting to reform the system because of Prop 187 backlash. Of course, 187 is also the penal code for murder. They came in and because the term limits, they got in office, and the first thing we started talking about was immigration issues. Start talking about criminal justice reform in the system, mental health, access to health care, whole new wave of legislators. And now fast forward 20 years, now criminal justice reform is kind of very common. Everyone wants to do something. Criminal justice reform. Immigration, there's been so many bills on immigration. Okay? And it would not have happened without term limits, without this new wave of legislators. We have different term limits now. But it's very fascinating to me that it took, or one of the byproducts of these really bad initiatives on immigration, bilingual ed, affirmative action, was this very active political force that emerged, especially people of color and women of color. It's really shaped what's happened in the Capitol. So let me stop there. Questions? All right, let's get into some good stuff. So what the hell's going on criminal justice reform? We'll talk a little bit more about immigration. What are the big issues right now? I think that's kind of what I want to cover. Okay. Do you have a question? Oh, there you go. All right. So, there's a lot that's happened. So let me mention, because I feel obliged to mention some of the work I've done on wrongful convictions. Okay. One of the problems when we talk about too many people being in prison is that some of those people didn't commit a crime. Right? Let's start there. Just that small percentage. I think everyone can agree, right, that we don't want the wrong person in there, right? And there's been a lot of work done over the last, 20 years about getting those folks out. Right? Not enough, but it's definitely started to happen. I worked on I put together a series of bills to address prosecutorial misconduct, because that's one of the ways in which the wrong folks get prosecuted and end up in prison. Okay? Prosecutors Typically, it's the situation is prosecutor has evidence that somebody else did the crime. They don't turn it over to the defense. Or there's evidence there's conflicting evidence. Witness said it was somebody, 5'7", light skin, light brown hair, and then they bring in, they arrest the guy that's 6'4", dark skin, long straggly hair. I mean, those things are actually happening. But the witness statement wasn't turned over. There was a case, and we'll talk about this, a mutual friend of ours, where the prime witness against the defendant was an informant for the police. A paid informant was never turned over to the defense. There were shell casings. There was a shooting, it was a double homicide. The shell casings were never tested. Things like that, things that weren't turned over, all fall into the bucket of prosecutorial conduct. At the front end of a trial, right? DAs and prosecutors are required to provide evidence and exculpatory evidence. They don't always do it. So one of the things I started working on is, well, how do we fix that? Like, everyone should agree that that's wrong. And what do we do about that? So first I ran a bill that was just want to kind of start the discussion in the Capitol. Because sometimes we do that. It's part of the strategy. So ran a bill that a jury would be informed anytime a prosecutor withheld evidence. Okay. Didn't guarantee any outcome, didn't change anything, didn't change the sentence, didn't do anything other than here's the jury. Oh, by the way, the DA, this evidence I presented that shows my client is innocent, the DA had that for 5 years and didn't give it to me until last week. Just thought you should know that. Okay. That's all the bill did. I mean, I couldn't get the votes on that thing. It was really, really hard to get the votes on that. But it started the conversation. Okay? And again, this is kind of the strategy in what I do. Because I did that hoping to get it passed, but I also knew it was laying the groundwork of educating legislators. How do you educate legislators about an issue? Okay? You can go in, have meetings, you take them to dinner, you can do those kinds of things. The other thing you can do is run a bill that's going to talk to them about the issue, get something done. But you have a full year of talking about what the problem is. Okay? And that's what we did with that bill. We explained it. He said, hey, this is what's going on. And you know what happened during that time? I had legislators and their staff tell me, like, well, that's great, but if prosecutors really are doing this bill doesn't do enough. It should be more. They're like, well, isn't that a crime for them to withhold evidence? And then it sets it up for me to say, as a matter of fact, it's not a crime. That's a good point that you brought up. It is a crime for a defendant to hide evidence. Right? That is a crime. But it's not a crime for the DA. Huh. I'll have to think about that. Okay. And it was all setting it up. Right. So a year later, I didn't get that other bill passed, but a year later I came back with a bill to make it a felony. Only felony I support. Felony for a prosecutor to withhold evidence. Okay. That passed, I think it was just about unanimous. Democrats and Republicans, and it got through. Even though when I wanted to introduce it, everyone said, you're insane. You'll never be able to do it. You can't put prosecutors in jail for withholding evidence. It just hadn't been done. The other thing we were benefiting from is there was a big case in Texas that was highly publicized, 60 Minutes, where the DA withheld evidence of innocence, and the person, I think, was convicted of arson and killing his wife and kids, setting the house on fire. Turned out he didn't do it. They had the evidence. And it was the first time, 20 years or 25 years later, they went ahead and arrested the DA. It was the first time in the country. But that DA had already become a judge. But they arrested the judge, and they only had, in Texas, they only had a misdemeanor available. So he spent 10 days in jail. He lost his law license, so couldn't be a judge. But it was 10 days in jail. It just didn't seem right if somebody lost 25 years. That was a very, very big case. So we had that, and we said, hey, in Texas, you only got 10 days, and in California, we don't even have a misdemeanor. So that's one thing that we did to start this conversation of prosecutorial misconduct. And before then, you couldn't touch DAs. Like, it was unheard of to run a bill all the time. So crazy people like me had to do something. But it also set up a broader discussion, because on that, as luck would have it, and this is my theory of life. It's like when you follow your passion and follow what you believe in, good things happen. Whether you plan them or not. Most of the time you don't plan them. But in working on that bill, I met a gentleman named Toby Anthony. Please Google him, please look him up. because I was, I can't remember if that bill or the other bill, one of the bills, I needed a couple of votes, and I thought, people are tired of hearing from me from the lobbyists. They can hear from somebody who's been impacted. Somebody introduced me to Obi. He was a gentleman I was referring to. That he was a homicide in LA. He received a life sentence plus 50 years. He was co-defendant. And it took 17 years before he was released. And the charges were dropped because he didn't do it. So it took him 17 years to be exonerated. And so someone introduced me to him, and I said, hey, I need someone to come and talk to legislators about cross-control misconduct from real life perspective. And he was willing to do it, to kind of share his story. And without him and his horrific story, his tragedy, we wouldn't have got that bill passed. The legislators who were on the fence heard from him, and they were like, we have to do something. We have to do something. The last fun note is that my first time speaking over here at this university, the day I was coming over here, he happened to be in town and in Oakland, and I said, hey, let's meet up in somewhere in the middle. Vallejo. I said, oh, I'm going to go speak. Why don't you come with me? I'm speaking on cross-control misconduct. Why don't you come and speak at the university, right? I mean, that's how it happened. And he's like, yeah, sure. So that's how this all started. Fast forward, he started an organization called Exonerated Nation. I'm on the board. We have another guy who's also on the board, has been doing some work on exonerees. Well, everyone's been, a lot of people doing work on the issue. But that's how it happened. That's how it happens sometimes. Okay? So, but that was something that I did a lot of work on, because that's one of the things. We talk about the pipeline to jail, prison. But part of the problem is the system itself, right? It's problematic. Okay. We're at a time right now in the capital, Sacramento, where we're looking at ways to really fix the mechanics of how it works. Okay. Okay. Let's get the wrong people out of prison. That seems to make sense. Let's do that. The other thing that's been happening in the last few years is sentencing reform. Okay. So one of the initiatives that was passed years ago was 3 strikes. Everybody sorted three strikes. Okay. So 3 strikes was you have 3 felonies in your lifetime. The third one, you get a lifetime, or you get 25 to life. Okay. Doesn't matter. No, I should say, if you have 2 violent felonies, third one, even if it's not violent, then you get the 25 to life. Okay. That was 3 strikes. That's, it's simple. You had 3 strikes. That has sent so many people to prison. Okay. Not just on the 25 to life, but you get in a situation, I would say, using people as examples of criminal cases, but let's just say you're facing a charge and you had 2 felonies from 15 years ago. Okay. And the way the law worked, you could have felonies before the 3 strikes law, and they will count against you. Okay, this is what was going on. So you did couple things, you got in a fight a couple times, you went ahead and pled to the felony, they gave you probation, paid a fine, no big deal. 10, 15 years later, you committed a felony. They're like, 3rd strike. And you're like, well, wait a minute, I want to fight this. You say, okay, you can fight it. If you lose, you get 25 to life, because it's 3 strikes. Or you can agree to plea out, and we'll give you 10 years in prison, even though it's a real minor felony. That's how a lot of folks ended up in prison. Not 25 to life. Found something less than that because they pled out. Okay. I had one of my early cases I was working on with another attorney. Was a gentleman who literally, when he was 18, got into 2 fights the same week at the local 7-Eleven, just hanging out. He was a little bit of a bull. Okay. He was. He pushed some guy, his gold chain. Hit another guy at 7-Eleven, took his $20 bill. 18 years old, before 3 strikes law. Pled guilty, I don't know, did probation, he was in for a couple weeks, no big deal. 15 years later, he got a felony, a non-violent felony. And I remember sitting just like I described right now, sitting in the holding cell, getting ready for trial. Would probably be the case. but that was the risk. You can go to trial starting tomorrow, or you beat it and then you're out, or you lose, you get 25 to life. Or they're offering you, I think it was 12 years. So when we talk about mass incarceration and we talk about, whatever it is, the mechanics of how the legal system works is largely a fault. The laws that were passed and the real life application, it's not just that it was 25 to life, it was that it leverages people to plead guilty. That's how it happens. That is how we ended up with a prison population that was more than double, right, the capacity, right? Which is why the state of California got sued. In the last 5 years, we've been trying to undo that. So 3 strikes by initiative got changed. So now the 3rd strike has to be a violent offense. Okay. And then they did some other stuff. We've changed felony murder rule was a big deal last year that was changed. So a felony murder rule is you commit a felony, in the course of committing the felony, somebody dies, you could be charged with murder. A lot of folks ended up in prison with that as well. Oftentimes accomplices or somebody who was there driving the proverbial getaway car. But didn't know they were going in. They knew they were going in to rob, or not rob it. That's actually not rob it. But go commit a burglary. But they ended up killing somebody inside, and the driver didn't know. Right? This happened a lot. The driver drives off. Boom, felony murder, because somebody was committing felony. In the course of that, someone died. A lot of people ended up in prison for a long time. That was changed recently. So what the legislature is starting to do is roll back a lot of the real draconian and really tough on crime proposals that were adopted. That's what's been happening the last few years. Because one, we have Democratic governors now. When Jerry Brown was here, he did major changes. And we have legislators and we have majority Democrats. Not always easy, supermajority Democrats, not always easy to get things passed. But they're more willing to pass these bills than in prior years. Okay? And when Republicans for a short period were majority. And so now they're really trying to do some of that. Let me mention one other one, and then we'll stop, ask questions. To me, it's very interesting because we're talking about the mechanics of the criminal justice system, right? That lead to the over-incarceration, that lead to the racial bias and the disproportionate number of people of color in prison, and disproportionately for longer sentences as well. More people of color arrested, or disproportionate number of people of color arrested, disproportionate number of people of color ending up in prison at the end. Okay. One bill that was passed, this past year, has to do with juries. Juries are a major issue because it makes a difference between someone being convicted or not convicted. And juries typically do not reflect the racial composition, demographics of the community. It just doesn't happen for a variety of reasons. I'll mention a few. But there was an interesting thing is that if you were on probation or parole, you could not sit on a jury. Or if you had a felony, if you had a prior felony, you could not sit on a jury. A long time. Imagine considering all of the way that our criminal justice system works and the disproportionate number of people that are arrested or people of color, all of that creates this kind of institutional, discrimination when we get our jury. So last year, Senator Nancy Skinner, out of the Berkeley area, authored a bill that said, okay, if you're on probation or parole, okay, you can't be on a jury. But once you're off that, you can sit on a jury. So now you're going to get individuals who have been through the system, who they have personal experience from from the defendant chair to sit on juries. Okay, that can cut a lot of different ways, but it's one way to kind of expand the jury pool. And the other thing it may do, and there's a lot of discussion about this, it might make a DA think twice about taking a case to trial. Right? Like, maybe I should plead out. Maybe I should just work out a deal because I might lose this case because it's a close case. And I may end up with some juror who maybe been through this. Yeah, maybe we should just work this out. Right? That probably will have the biggest impact, right? But it'll be really interesting to see, and I think going forward, a really interesting area to study what the impact has been. How many folks who've had prior felonies will end up on juries? What was their experience? What did they bring to the table in the juror deliberations? You know, how did that go? How did it impact those discussions? I think it's going to be fascinating. The last thing I'll mention, I lied, I'm going to have one more thing before we stop for a second, is I'm working on a new bill this year with a number of folks, including the death penalty clinic at Berkeley School of Law, Bold still. And that has to do with racial bias in juries. Okay, there's mechanics now. There's a way. Let me just lay this out. So, how many of you have been not only had jury duty summons, but actually ended up in the box being questioned, even if you didn't make the jury? Oh, you probably got kicked out. One, anybody else?
Yeah, I got kicked out pretty quickly.
Yeah, I would imagine. Okay. So the way it works, there's a jury pool. They tell you come in, you can play, I gotta go to jury duty. You show up, you might end up in the courtroom, maybe in the audience, and then they put a number of folks in the box, the actual jury seats, and then they ask questions, and then some people get kicked off because they have, they're like, oh, I know the victim, or whatever it is, right? So you can get kicked off. You have a bias, like explicit bias, where you say, yes, I can't be fair in this case because of X. So, or there are a number of reasons why you get kicked off automatically. There are others where they just ask you questions. You don't have demonstrated bias, but the attorney, the DA or the defense can kick you off. Okay? Peremptory challenges. Okay. I always got peremptory challenged out. He always kicked me out. I said, no, I can be fair. I absolutely will be fair. I believe in innocent until proven guilty. And they never wanted me on juries because of that. They tried very hard to get me out for trial, but they couldn't do it. And so what happens when a prosecutor, this happens frequently, when a prosecutor uses his or her peremptory challenges, those are the challenges you can just kick them out for whatever reason, well, some exceptions. What if they happen to keep kicking out the people of color? And we're talking about the demographics of the jury. This happens a lot. Okay. Without getting into all the details, there's both federal law and state law about how that's handled. Right? So I'm the defense attorney. I'm like, hey, the prosecutor keeps kicking out all the people of color. There's a problem with that. Basic rule is if the DA can say, no, that's not why. I just don't want a juror that likes to eat potato chips. That's not a racial reason. It's just what I don't want because this case involved, someone who worked at a potato chip factory or whatever. I don't know, whatever. Okay, as long as they can come up with an example of something that's not racially, or not a racial reason. That's not quite enough, right? You go, it just doesn't feel right, What if they say, well, I don't know, this person has, bad experience with the police. I'm going to kick them out for that reason. Technically, under the law, that's not a racial reason, but when we know the bias in policing, who's more likely to have that negative experience demographically? People of color, low-income folks. So what we have this year is a bill authored by Assemblywoman Shirley Weber. Don't remember the bill number, but I will. That will create a new way for a court to determine whether or not a DA is improperly discharging jurors, okay, based on implicit bias, not explicit racial bias. Something kind of new, but the good news for us is that the state of Washington just adopted very similar policies, and they've rolled it out. So it may be, someone's feelings towards police officers, their experience with police officers, and live in a certain neighborhood. They have, there's certain things that maybe on the surface aren't racial, but it's kind of, it's one of those things I would say, it kind of doesn't pass the smell test, right? It's like, oh, you keep getting rid of everybody who's, whatever it is, right? So that's what our bill is. It's creating the opportunity to ask a judge to identify improper discharging jurors, okay, for a number of reasons that are not racial on the case. Okay, it's going to be a very interesting discussion. It's going to be a very interesting debate. I don't know if it's going to pass or not. I really don't. That'll be my job. The lobbyists get the votes, right? Ultimately, a lobbyist has to be a number counter. I need 41 votes in the Assembly, I need 21 votes in the Senate, and I need the governor. It's going to be very, very interesting. But it is another way to attack the criminal justice system and the racial bias in the criminal justice system in a way that's not always thought about. It's not necessarily going to make the headlines, but it can make the difference in individual cases. So that is something I'm working on. Keep you guys updated on that. It's going to be very interesting. I'm not sure how that's going to turn out. But let me start there. Let me hear what questions you have, what you want to talk about, what you want to know about. I'll give shorter answers. So we have, I don't know how much time we have.
Oh, we have until 6 o'clock for our, okay. And then we'll give.
I just have a question about, you said it's a crime to withhold evidence.
For the DA to withhold evidence.
Who prosecutes the DA?
That's a great question.
Who decides whether they're going to be prosecuted?
That is a great question.
DA?
We haven't had anybody prosecuted yet.
Okay.
But the way it would play out is likely the Attorney General's office.
Okay.
Yeah, and I've had discussions with the Attorney General about this. So we are working on trying to create a little pot of money and some protocols for that. It'll be very interesting the first time that happens. Lisa.
Why would the prosecutor withhold evidence if
It's a great question, right? That is absolutely right.
Great question.
Who knows? I mean, it is, sometimes they really believe it's the person. They're just like, it is, I know, I may not have all the evidence. I don't care what this other evidence shows. I just know it's Lisa. I know it is. Okay? It may be they're trying to, I had a case where, I think how to summarize this. There was an issue with the sheriff deputy. Okay, and if we could prove that our guy didn't do it, we would show that the sheriff deputy shot my guy. Okay, the sheriff deputy claimed that our guy tried to run him over, something like that. So we shot him, so we wouldn't run him over. It didn't happen that way. We could actually prove that. So, but the DA had evidence that this sheriff deputy had shot 4 other people. And been investigated for that. Okay, 4 other people. It took 4 years, 2 days before trial, before the DA gave us that information. Oh, I just found this. Oh, convenient. So why? They were trying to cover up, right? Trying to cover up. There also had been, they had also stated under oath that there had been an investigation of whether or not the deputy had violated departmental policy or committed a crime, and he said he had been cleared. Said it under oath to the grand jury. Turned out that never happened. Okay, so they do a lot of things like that for different reasons. And that situation was a cover-up law enforcement. In Obi's case, the informant was an informant for the police. It also happened to be the crime scene was an unofficial brothel for law enforcement. So they needed to pin it on somebody, and not one of their guys who's an informant, because that informant knew all about the brothel and, they can't prosecute it. That's their guy. Sometimes it's that. But a lot of times it's the first part where the DA is just locked in. Like, we pinned it on this person, I've staked my name on it, and I can't back off. Now, not all DAs are like that. Okay. As they say, I have friends that are DAs, and, they're much better than that. But there are folks who will do that. Yeah.
Question. I know when you had this presentation before, you talked a little bit about the public health implications of bail reform, for example. And can you give an example of that?
As far as like getting people out, not getting people out, or
Yeah, why bail is a problem, what
gotcha.
the issues that might have
Absolutely.
implications for public health.
Absolutely. So bail reform is a very interesting topic. And I have some, these are my own views, and I also have my clients' views, although they are. Happen to be. So bail reform, the basic issue is, someone's, Lisa's arrested again. She keeps getting arrested. Sorry, Lisa. So you get for speaking up. She's arrested and it's a felony, and she's arrested on a Friday. And she won't have an arraignment, her first hearing or first court appearance until Monday, Tuesday. She has to go to work Monday, or she works on Sunday, whatever it is. She wants to get out. So how do you get out? Bail, right? So bail basically is just, there's a bail schedule that's set. So let's say whatever your crime was, it's a $50,000 bail. Okay, you don't have $50,000 lying around. You're like, I don't have that much. So you go to a bail bondsman, and they put up the $50,000, and you typically it's 5%, 10%, depending on the business model. You give that money to the bail company, and the bail company puts it to rest. You get out that day, you're home free. You get to go to work, do your homework for class, whatever it is, right? So you're free. Now the big issue was that some people can't afford bail. Okay, even that percentage that goes to the bail company. Sometimes bail is set so high, there's just no way to do it. It used to be that you could use a property bond, right? You put up the house's value has to be 3 times the amount, or the equity has to be 3 times the amount of the bail. I think that's what it was. They used to do some of those way back when, used to file those. But that's changed a lot, especially when people's homes weren't worth as much. But if you couldn't afford it, you end up staying in jail, in county jail, until you go to trial. Now, unlike Law and Order, trials don't happen like the next day, right, or the next week, right? I mean, they go pretty fast. But in real life, trials don't happen that quickly, for the most part. It takes months. It could take a year, depending on how complicated it is. So if you don't have the money to pay for bail, you're stuck. And in fact, a very, very large percentage, I'm blanking right now, but a very, very large percentage of people in county jail right now are there pre-trial, have not been convicted of anything. Okay. Not been convicted, they've been arrested, they can't afford bail. Okay. And that is the rub. Okay, because again, we're talking about disproportionate people of color, disproportionate men of color, say, who are arrested for crimes, disproportionate low-income folks. Okay, and when you look at who can afford bail, who can't afford bail, you end up with the county jail looking like it does. Okay, and they're stuck there for a long period of time. In theory, the community believes the jail is there for someone who actually committed the crime and is convicted, and that's actually a very small percentage of people, especially in county jails. So bail reform was essentially a bill that's got rid of money bail, what they call money bail. And instead, the general notion was that, obviously what happens if if you're in jail, what happens to your family, what happens to your job, you lose your job, what the impact is on the family. The rest of the family has to find a way to cover the income that you had. I mean, the things that just the cascade of things that happen. It just goes on and on. Bail reform said, okay, money bail, we're going to get rid of money bail, and instead we're going to certain offenses we're going to let you out. Other offenses we're going to do a risk assessment and decide whether you get out or not. And some offenses we're just going to keep you in there just in case, before trial. Now I can tell you my personal view. A little bit controversial, not entirely. My personal view is I support getting rid of the bail model, okay, money bail model. Okay. I did not support, my client did not support the final version of the bill that was passed by the legislature. It was historic. It was on front pages. Bail reform, California gets rid of money bail. Great headline. The reality is I think it's extremely problematic, and in some ways can be worse. Okay. And it's unfortunate. And here's why you guys will appreciate this. So just two things. There is a risk assessment, and then there's certain offenses that you can't get out, or it's presumed that you're not going to get out before trial. On the risk assessment, they're going to take somebody else. Take Rachel. Okay, Rachel gets arrested for something. It's an offense that's not an automatic kick out, and we do a risk assessment. See, who you are, what the offense is, and we decide. We do a little test on you. We decide, oh, you're too much of a safety risk, public safety risk. So we're going to keep you in jail before trial. Now, under current money bail, you can be like, well, you think I'm a risk? As long as I pay the money, I can get out. Under this new system, risk assessment says, you're too much of a risk, you can't get out. Not even if you put up money. There was an article that just came out recently where a number of experts said the risk assessment was racially biased, that they cannot find a risk assessment tool that is not racially biased. Problematic. So on the one hand, it's good at getting rid of money bail. On the other hand, money bail was a safety valve that if all else fails, you can't convince a judge to let you out. You can at least find somebody to put up some money and put you out. The last piece of it is there are certain offenses you're presumed to stay in jail before trial. Okay. One example would be a DUI when you have a high blood alcohol level. I forget what it was. It was 0.15, something high. Then you can't get out. It's presumed you cannot get out before trial. Okay. And then you have to go through a special motion to try to get out. Not a violent crime. Okay. Just a high blood alcohol level. Now I'll tell you this. Pretty steady for the last 10 years. 50%, 49 to 50% of all DUIs in California, all people that are arrested for DUIs in California, are Latino. Not people of color, just Latino. Half of DUIs. So when I saw that in the bail bill, I was like, DUIs. I know which population this is. Like, it's not even, close. We know who's going to be held, even if they can afford the bail. The last piece of this, and then there's questions on this, is that in my view, the bail schedule, okay, how much bail you have to pay for each offense, is really the major culprit. Right? It's too high. Okay? And judges won't lower them. Now, who sets the bail schedule, right? That's like a menu, right? Robbery this, burglary this, whatever, right? Who sets the bail schedule? Does anybody know who actually writes the bail schedule? And I can tell you each county does it separately. Each county has its own bail schedule. Anybody know? Any guesses? Prosecutors? No. Good guess, but not. It's the judges. It's the judges. So from my view, and again, I'm coming from a defense perspective, it's a very strange situation because we have the judges who set the bail schedule. And if Rachel goes in and gets bail set at $50,000, my attorney like, that's ridiculous. That's way too, or $150,000. Like, that's way too high. It should be $25,000. The same judge that might have been part of the committee to set the bail schedule has to decide whether or not to let you out on a lower bail or reduce bail. And the judge goes, no, I'm not going to let you out. I think she's too much of a risk. So I'm going to keep the bail at $150,000. Can't get out. That combination of a high bail schedule and judges not being willing to reduce bail or waive bail, I think is the major contributor to people being in jail pre-trial. It's not the bail companies. They just make money off of it, which a lot of people don't like. And I get that. They're making money off of somebody's misery. I get that. But they're not setting the bail schedule. The last thing, and then I'll take questions, is that the final language of the bail reform bill that was passed, that had this risk assessment and it had presumption like DUIs and some other things that you can't get out, was written by the judges. Okay? At a time when there are cases in front of the California Supreme Court, and I'm talking about the Chief Justice was involved in this, California Supreme Court Chief Justice. There are cases in front of the Supreme Court right now that could get rid of money bail. And what they're arguing, the defense is arguing, defendant side is arguing that bail should be set on an individualized basis. $150,000 is too much for Rachel. And in this situation, Rachel should have a lower bail. In Nicole's situation, it should be higher because Nicole's really bad or whatever it is. But it's individualized on what someone could afford. So that there's always a way to get out. That's what's being argued in the Supreme Court. And it would take the power away from the judges, right, to set the bail. They have to go, well, what's fair to Rachel? What's fair to Nicole? What's fair to Gail? That's what's being debated and will be decided soon in the Supreme Court. Okay, so for me, the judges are a big part of the problem. They're the ones that pushed the amendment. The last thing is that the bail reform bill, SB 10, is actually on the November ballot. So you'll be voting on whether to keep SB 10 or to get rid of it. The bail companies are trying to get rid of it because it puts them out of business. And the reform people are all over the place. Because we know that we do want to get rid of money bail, but we don't necessarily like SB 10. Back here and over
I
here.
was gonna ask about SB 10.
Yeah.
Whether you were alluding to that.
Yeah, that's SB 10.
Dialogue, okay.
Yeah, that is SB 10. Sorry, I should have mentioned that. So those are familiar. So it's going to be a very interesting debate. So you had hands you have Rachel.
Yeah, just a quick question. Where did that bill money go to?
So the bail money goes, Christian's arrested, $150,000 bail, you go to bail company, you put up $15,000, you make all your court appearances, you don't skip town, leave the country, the case is done, the bail company gets the money back from the court. Because you give the bail company
What
$15,000.
is the court doing with that money? Just say.
That's a good question. I like how you think. But at the end of it, the money comes back to the bail company, but you're still out for $15,000. Right? They keep that. Right? That's the service fee. They keep it in an account. I don't know if they make interest on it or not. I don't know. Good question.
Is,
Again, my perspective, I don't want to bias you guys one way or the other. Just being in the middle of it and having to decide what to do, and having supported SB 10 before those changes, I think my client was the first organization to withdraw support and go to oppose. It was very difficult. But anyway, Rachel.
So who's administering that risk assessment? Is it the judge or just?
County probation. There are different models. Typically, it's the local county probation office. I think also in consultation with. I'm trying to think how they do it. I forget exactly how they do it, but it's not the judges or it's the risk assessment. I think led by the county probation. Santa Clara County is supposed to have a pretty good model. They look at a lot of different things. But again, there's a debate if it's going to be good in some situations, maybe not. I don't know. I mean, I go back and forth on risk assessment because, anyway.
One little question about risk assessment.
Yeah.
So they're not always the same in terms of the questions, the tools that they use, or they vary across
That's
county
right.
lines, state
That's right.
lines.
There's not a set, right. There's not a set. Yeah, it's different county by county, right? And that's been one of the issues that has come up. So it's a tough situation because the end result is we want fewer people in jail pre-trial. But the flip side of it is some people, and we get this, the competing issue is that you don't want, do you want to release somebody who is a risk to public safety? Right, because that comes up quite a bit. Like, okay, Nicole wants, can post bail, but Nicole, if we put her out, she's gonna go out and hurt somebody. Right, and that's where I will understand where the judges are coming from. That's where they're coming from oftentimes. They don't want to be the judge to be like, oh, yeah, I'll waive bail, and then the person they waive bail or drop bail goes out and commits a horrific crime. Like, oops, right? I mean, that's legitimate. I mean, that's a legitimate interest. Don't have my clients on. It's, it's a legitimate something to look at. The reality is that the law says you have a right to bail. Right? The California Constitution says you have a right to bail. So how they get around that? In SB 10, someone's asking about SB 10. This is great how this happens. SB 10 says, this is the law, right? And lays out the new law. And it says, this is the law to the extent the California Constitution allows it. So California Constitution says you have a right to bail. And the bill says no bail. So it's very fascinating. But the bail, it's, I can tell you the view of my client, and this is public. The view of our client is we're preparing either way. If SB 10 is voted out, we have amendments to the bail law that we think will be helpful to get people out pre-trial. If SB 10 becomes a law, we have amendments that we think will improve SB 10. So at the end of the day, we're just ready to do some work. But the damage that is done with somebody being in pre-trial on a whole variety of levels is really undeniable. Okay? The impact. And if you know how long it takes, the criminal justice system takes just to process a case, you know, you're in there for a long period of time, and you might as well you might as well have done the crime, right? That's the worst part of it, right?
And those days aren't counted towards your actual.
No, they are. Credit for time served. Yeah, they can be. But the other thing is, some folks didn't commit the crime. Some folks didn't commit the crime that they're charged of. They committed a crime, but they're overcharged. Okay. It's another bill we'll work on. Because that's kind of how the system is set up. There's so many different levers in the system to help push more people in jail, both pre-trial and to be either convicted or to plea out. Most cases plea out, but they're leveraged into pleading out because they're afraid of a longer sentence or whatever. Some people committed the crime. Okay. I mean, let's not forget, some people actually committed the crime. And sometimes it's a legitimate crime that probably should be unlawful. Sometimes it's a little, maybe it shouldn't be, or maybe the sentence is too long. I mean, we could try to fix those. Sometimes the law is ridiculous. But oftentimes we get it. Okay? We don't like it. That's what has to happen. Question?